Welcome back to our webinar series at HospitalityLawyer.com and our Converge blog. Today is May 20th, 2021, and we've invited back again Miss Andria Ryan. Andria is a partner in the law firm of Fisher Phillips, co-chair of the Hospitality Law Practice Group at Fisher Phillips. And Fisher Phillips, as you probably recall, is a national law firm representing employers. We're always thrilled to have Andria with us. Her and her team do an outstanding job of providing guidance, not just across the labor and employment spectrum, but specifically from our perspective to the hotel, restaurant, and other hospitality entities that are out there. Welcome back, Andria.
Thank you, Stephen. I'm happy to be here.
Well, it's always nice to have you, and we're going to jump right in. As you know, there's some real challenges with hiring people today, primarily in the hotel and restaurant industries, for a variety of reasons, which we are not going to go into today. I'm writing a separate article about that. But I do want to have a dialogue today with you about these staffing agreements. Because labor is becoming so challenging, many entities are turning to staffing agencies. They're signing these agreements, and I'm not convinced that they are in the best interest of the hotel or the restaurant. So we need your insight as usual.
Well, Stephen, your instincts are absolutely on point. We have a combination of some, shady operators and some very, very good ones as well.
Yeah. And
agreements that are really not comprehensive enough to protect the hotel operator. And so, it's a twofold process. One, hire the right staffing agency and then get the right agreement in place.
Well, that's terrific. So let's kind of break it down into two pieces. Let's start with that, hiring the right group in the first place. So in our previous conversations, we've talked about the need to vet these businesses. How do you go about, what do you suggest that we do to go about doing this? I mean, we could all do a Google search, but clearly there's more to it, right?
It is. I mean, we want to make sure they're licensed to be doing, in the state that they're doing it, they want to be licensed. When you check on the Secretary of State's office or your licensing bureau, also check to see whether there are 2 or 3 or more companies using the same or a similar name that are, because what we tend to find with our shadier operators is when we get a violation, maybe an immigration violation with one, we start up another company with a similar group of principals. So take a look at that to see if you're seeing that commonality. Ask about insurance. You want to make sure, and proof of insurance. Mm-hmm. I'm going to build that into your agreement as well, but let's see that up front. Let's just you're dealing with somebody with a reputation that they were able to get the right levels of insurance, workers' comp, general liability, all those things. And do reference checks. Call a handful, a couple of other operators. Unlike employee reference checks, where we're all really hesitant to say anything, someone that has a good vendor relationship should be willing and able to give you a good reference for them.
I was just going to ask you that there's a key distinction between those two types of references, and we really don't have the hurdles of sharing our experiences with a third-party contractor with others in the industry.
That's right. Right. If they're a good vendor, we ought to be recommending to our fellow operators. The other thing I would do is ask the vendor, the potential staffing agency, a high-level person, what their experience has been with the Department of Labor, with immigration authorities. Have they been fined in the past 5, 8, 10 years? Yeah. Because those are some of the caveats I'm going to build into the agreement as well. But I'd ask the question right up front. Have you had any major, penalties, violations, or fines from any state or government, federal agencies?
And would it be fair to also ask, have you been in any litigation around not just the contracts, but from employees? Is that a fair question to ask?
Sure.
Yeah.
Litigation is lawsuits are public information as well. So
Right.
if you have the resources, you can go and look yourself to see, where the company shows up. But then I'm going to go back to my original caveat. It's often the reason people change the name of the company. So it's a little harder to track.
Very good. That's a very good point. I want to jump back just for a second on that reference. And look, if you've been asked to give a reference or you've been asked for a reference, we're sharing with you. We think it's okay to do that, good or bad. Just be accurate.
That's right.
Right. Yeah. That'll keep us.
The defamation laws apply in business as well.
That's right.
But truthful information about your experience with a vendor is fair to share.
There you go. Okay, so that's helpful. Just to recap, we're going to vet, and we're going to vet by asking the questions you talked about, doing the look to see if there are any similar operating names out there or similar ownership groups under different trade names. Yeah, litigation, any violations of laws, compliance issues, fines, etc. All very helpful. And that insurance item you talked about is very important in this case. And I just want to real quickly, and you may be going to touch this in the contracts discussion, but I want everybody to understand that if they indemnify you, if the staffing company indemnifies you, and I'm going to allow Andrea to talk about whether they should or not, but if they do, you want to make absolutely certain that there's insurance behind that indemnification. Because if there's no insurance behind it and it's a zero asset company, in other words, it's just cash flow coming in and cash flow going out, there is nothing there to reimburse you for the indemnification. And what I want to make clear to you is just because somebody indemnifies you, that doesn't keep you from getting sued. It doesn't keep you from getting a judgment against you. It means that once that happens, then you could look to the indemnifier to reimburse you, but they're not going to do it up front, and it's not going to preclude you from being involved in the litigation. Is that a fair recitation of how that works, Andrea?
It is fair. And dovetailing on that thought, Stephen, there's always the issue of joint employment out there. We do the best we can to have these relationships be as arm's length as possible. Right. But in addition to the potential you get sued and then you have to look for indemnification, you may get sued as an employer along with the staffing agency. So yeah.
And then you've got to work that out. And that's challenging. Yeah. That's for another video though. Okay.
It is.
All right, then let's talk about some of the clauses in the contract, but from a general perspective, how do I need to think about this contract?
Stephen, you need to think about this contract at a higher level than your housekeeping manager negotiating a staffing agreement.
Okay. Yeah.
Right. That's I can't tell you how many times I walk into an operation and say, we've pulled together the contracts. We've got 3 or 4 and they're signed by a housekeeping manager or an executive housekeeper. It's not even there anymore. And it's a 1 or 2 page document handed to us by the staffing agency. And all we really concentrated on was the pricing. And so I really want you to execute whatever agreement you execute. And of course, I want you to execute yours, not theirs. But I want it at a higher level. I want a GM, I want an owner, an operator to be looking at that agreement and be the signatory on it. Okay. Your housekeeping, Stephen, as we know, your housekeeping manager is binding you if they sign it.
That's right. Yeah, they've got that agency typically is the way that works. That's exactly right. So you've got to be very cautious about authority that is being granted to different people. Okay, and so Andrea, in your experience, my experience is kind of like these agreements that are handed to us by the staffing companies, they typically protect the staffing company. And clearly we don't want to step into that, right? We're paying them. We need this document to protect us fairly, right? Neither one should be one side or the other, right? But it should be a mutual fair agreement, I think. How do you feel about that?
I do. But let's remember, they control the employees and the employment relationship. That's out of your hands until that employee shows up, the temporary employee shows up at your hotel when you have a little bit more control. Yeah. Before they get to you, the staffing agency controls everything. And so your agreement needs to address that first. I mean, obviously, description of services and the pricing that makes sense for you from an operations and a business standpoint.
Mhm.
I'll set that aside because y'all are way better at figuring out than I would be.
Okay.
But this is what I am going to worry about for you. And that is, we want to certify compliance. We want that agency to certify compliance for a number of areas. Equal employment opportunity and harassment, wage and hour compliance. Are they paying their employees properly? Taxes and withholding. Record keeping. Are they keeping proper payroll records? Immigration compliance. We'll probably visit that one again in a moment. Workers' comp. Background checks, drug testing, we need to build in their certification that they are in compliance and going to remain in compliance in all those areas.
Wow, that's a lot to think about.
Well, it is, but let me highlight two. And I'm going to highlight wage and hour and immigration compliance, because those agencies at state and federal level are so active in terms of investigations and fines and penalties. If your staffing agency is not properly paying overtime to these employees, the wage and hour division is going to get their money from someone.
Right.
And if they can't find the staffing agency, and hundreds and thousands of dollars potentially are owed to these housekeepers that have been working 50 hours a week, they're going to come to you.
Right.
And immigration compliance is, there's criminal penalties associated with immigration compliance, non-compliance as well. But to go along with this, Stephen, I mean, it's one thing to say in our agreement we'll be compliant, but we need a right to inspect.
Right, and a right to audit, right? We need to be able to ask and receive things quickly. I think that's crucial. And Andrea, just real quick, back to wage and hour, the overtime example is a good one because that can be frightening, the amount of money that can add up quickly there. But what about trust fund taxes? The withholding and things like that. My experience is the IRS, like you said, they're going to get their money from somebody, and assuming if the hotel has gotten the benefit of the bargain, right, they're gonna. I'm not sure the hotel's going to be protected. I don't know the answer, but it certainly would be a battle. Well,
the IRS is a formidable opponent, and don't forget the state unemployment, Department of Labor, because unemployment taxes have not been paid.
Oh man! And then of course, if comp isn't paid and there's an injury. Right. Then you've got the employee looking to anyone, right, who might be responsible. So the litigation could happen there as well without the potential protection of the workers' comp ceiling on damages if they were able to get through.
And I don't want it to sound more complicated than it needs to be. I think that if you look at a good agreement that that I would suggest you use is, and you just hold it side by side with the one that you're being handed by the staffing agency, theirs just doesn't address it generally. Ours simply wants to say you certify that you are in compliance.
Yeah.
And of course, a right to audit.
Right to audit. Very helpful. Right. Okay. What's next?
What's next is cooperation. These employees are going to be on your work site. And so if one of their employees gets accused of harassment, for example, or a temporary employee accuses one of your employees of harassment, you want the agency to agree to cooperate with you in investigating misconduct, policy violations, accommodation requests. If their employee asked for an accommodation for their disability, for example, you need a cooperation, an agreement to cooperate with you in a timely manner, make witnesses available, attend meetings with you, have their management attend meetings with you. We want cooperation there. We want cooperation on safety training. They'll make their folks available. They'll show up on time. They'll participate. And any other property level training that you think is important. I always urge you, don't put your temp employees through the same routine that you do your regular employees.
Yeah.
But some training is important for anybody that's on your property, right? Safety
like general safety and security, and aspects.
COVID protocol, right?
Protocols, right. And things that are peculiar to the property itself, for sure, need to be done. Yes. Very helpful, Andrea. Okay.
Well, so then I want, obviously we want them to properly administrate it, proper administrative services, that their books are going to be good. They're going to report their expenses properly. They're going to certify to you that they're, in compliance with their business licenses and things like that.
Yeah. Paying timely. Yeah.
That's right. And I want you to have I want you to have a strong termination provision. Obviously a termination provision with maybe 30 or 60 days notice, but I also want a provision that you can terminate this agreement immediately in some situations.
Yeah, that's helpful. So when we're talking about termination, ladies and gentlemen, we're not talking about terminating employees here because they're not your employees. We are talking about terminating the agreement with the staffing agency, right? So she wants a strong clause in there with the opportunity for some reasons to terminate immediately. Can you give us an example or two of what those might look like?
So, and I hate to go back to immigration, but I had a bit of a jaw-dropping moment one day. I was sitting with a group of managers, an executive housekeeper, who was fretful about the lack of staffing. And she said, we've got a good staffing agency here, but I can't hire any of them because they're all illegal. And I said, as my eyes popped out of my head, this is an attorney-client privilege conversation, thankfully. But I said, if you know them to be staffing your hotel with illegal, unauthorized workers, you can't continue to employ them, and you must end this agreement today.
Yeah.
Because again, in addition to the regular penalties, there's criminal penalties associated with knowingly hiring folks that are unauthorized to work. So
yikes. Yeah. So Andrea, just kind of a little bit off what we're talking about right now, but if the hotels can't find these employees, how are the staffing agencies finding these employees? It worries me a little bit.
Yeah, and it should.
Okay.
It should. I think there is some level of folks that can't. There's certainly a group of employees that don't care about it and want to work as needed. There's some folks out there that do that. But there is another group of employees that likely wouldn't pass your background check, might not pass your drug screening,
your immigration status, et cetera. Yeah. Okay.
So we that's why we want to deal with someone reputable that is doing their best to hire folks that you would feel comfortable in your property and with your guests.
For sure. Great points. Anything else that we need to think about on the contract? Do you think we've covered it?
No, we want to make sure we have insurance in there. We talked about verifying it, but we want to make sure it remains in place. We want an indemnification provision. Steve and I talked about it can look a lot of different ways, but it's important that you protect yourself if they've done something wrong.
Right.
And then a clear definition, a clear recitation that this is an independent contractor relationship.
Right.
You're responsible for this and we're responsible for this, and neither of the two will overlap, or as little overlap as possible.
Yeah. Andrea, as we go through this, there's a lot to this. And I know we didn't want to complicate it, but the fact is, whenever you're dealing with employees, it can be complicated with all of the things that you've mentioned, whether wage and hour, immigration, et cetera. So Andrea, as I'm mentally trying to balance the benefit of the third-party staffing agency with all of the potential challenges, which side of the fence would you come down on? Is that a fair question? If you were an operator, do you feel like it's worth it to go to this, or let's make, because look, clearly there's some benefits. I get that. But we've just identified some real potential challenges and that we are actually kind of giving up control over.
I think you've got to have hit the point where you have exhausted your ability to fill these roles.
Okay.
Right. Because I think it should be a backup. And once you've moved to the backup, the question is, do not let it be a long-term solution.
Okay.
Continue to recruit. Use these folks. Don't use them for 6 years.
Right.
Use them for 6 months.
Yeah. Is it fair from your perspective? And that I just want, let me recap that real quickly. So what I hear you saying is we feel like the employer-employee relationship is probably is the best approach unless we've exhausted all of our pathways to hiring employees, and I just have to have a pipeline of other folks. And then I turn to a potential staffing agency with an appropriate contract that's a fully vetted agency. But as soon as the labor market opens up and I can hire people myself, you're suggesting we get back to that approach.
That should be our goal.
Okay. Yeah, that's very helpful. And I think that's a good mantra to follow. Yeah.
Now I don't want you to worry about these agreements. I think that in one sense, once you have an agreement you're comfortable with, that's yours, then you just continue to use it. Your pricing and your services and those descriptions can be an exhibit to the agreement, but it's got, I don't want to overly complicate it. Once you have an agreement in place that you're comfortable with, that provides the protections you need as an operator, you just keep using it.
Right, exactly. Okay. And to be fair, right now, they probably, with this video and the information in this video, you could go talk to a local attorney, because that's important, right? Because state laws, in some cases, municipal laws are going to apply, and they need to get it drafted by that, right? Or at the very least, they should have the hospitality staffing companies, temporary staffing agency, I'm sorry, their contract reviewed by their own counsel, who only has their interests in their sites.
Correct.
Yeah,
that is correct.
Okay, and of course you can talk. Fisher Phillips has lawyers all over the country. They can handle this in almost any state. They're one of the most reasonable law firms we've ever had the pleasure of working with. And so I encourage you to reach out to them. And listen, before we wrap up, I do want to suggest that you go to the Fisher and Phillips law firm website, because they have extraordinary resources available for you that you can access.
Yeah, we do. We're very proud of it. So
yeah,
go ahead and visit us. We're FisherandPhillips.com.
There you go. It's great stuff. Andrea, anything else on this topic before we wrap up?
No, good luck. I know it's very challenging out there, especially in light of our attempt to move into more normalcy now. So it's very challenging, but be cautious. Protect your business.
Great thoughts, Andrea. As always, thank you very much for sharing it with us, and we will be in touch soon, I'm sure.
See you soon.
Thank you, everyone. Bye for now.